Good evening, everybody. Welcome to the annual SEPAC Rights and Responsibilities Training. We're excited to have such a full room. Can you all hear me? The microphone is mostly for the videotape, so not to amplify my voice. So we are really excited to have Colleen Shea here from the Disability Law Center and Nicole Merhill here to talk to us about 504 accommodations. I think it's going to be a really exciting evening. Just so you all know, we are filming this presentation for HCAM, so we'll be able to share it with other parents who couldn't attend tonight. We are going to film the formal content of the presentations and then turn off filming for the question and answer section. So, you're welcome to ask questions through the formal presentation as they come up. But if you would prefer to save your questions so they're not on camera, there'll be an opportunity for that too. Sound good to everybody? All right. So, just a quick introduction to SEPAC for those of you who aren't familiar. I'm Katie Goggin. I'm the chair of SEPAC. Jen Doan is the secretary of SEPAC, and Tricia Burns, who I think is coming tonight, but she's not here yet, is our public relations and outreach coordinator. So SEPAC has three major roles. One is to really advise the school committee on matters relating to special education. And the second sort of dovetails is really meeting regularly with both school committee members and the administration to advise them. And then the third one is why we're here tonight. We are legislatively responsible for conducting this workshop about rights and responsibilities related to special education. So our SEPAC has outlined sort of three major things we want to accomplish this year. One is continue advocacy efforts. As many of you know, we had a really busy advocacy year last year and continuing into this year. And we really want that advocacy to be driven by the parent survey results, which I know many of you completed. We want all of our efforts to be supported by research, promote transparency, and focus on accountability. We're also working really hard this year to have more parent support and engagement events and continue that work that's been done over time. On the table over there, if you didn't pick one up, is our annual calendar. We have a very informal, easy conversation parent breakfast the first Thursday of the month from 10 to 11 at Brugger's Bagels. And then our monthly business meeting is the second Wednesday of each month at the library from 7 to 9 p.m. And then finally, our third focus area is on parent education. So stay tuned for more events in these areas. So and if you need to contact us or want to contact us for any reason, there's our email address. We also have a pretty active Facebook page and a website, which is continuously under construction. But we're slowly but surely getting there. All right, so without further ado, I'm going to turn it over to Colleen from the Disability Law Center, and I'm going to, for folks that didn't pick it up, her presentation handouts are there, as are Nicole's.
Hi, everyone. Thank you so much for coming out tonight. My name's Colleen. I used to be a 7th grade special ed teacher, and then I went to law school, and now I'm representing low-income students with disabilities in school discipline matters. That's sort of the area of practice that I'm focused on. But tonight we're going to focus on sort of a broader area of just basic special ed rights. Feel free to chime in with questions, concerns, and I'm going to move pretty quickly, so feel free to raise your hand if you have questions. So that's a little bit about me. Oh, I have to man this thing. So this is sort of a broad overview of what I want to get through, just talk about eligibility, annual reviews, what on earth FAPE and LRE mean, the IEP placement process, right to independent educational evaluations, and then I just wanted to briefly go through discipline, because it's my baby, and touch upon bullying as well, because I know that's a constant issue in every school on the planet. And then briefly touch about the dispute resolution process if there is a problem. I did pass around, I didn't give it in advance, so I just passed around some handouts. Those are some resources. I'm just going to reference them as I'm going through the presentation, and hopefully they can be resources when you leave here. So special ed is based on a few laws that overlap and can be confusing. IDEA and Section 504. I know my partner here is going to speak about the 504 process a little bit more. There's also the Massachusetts regulations, and then I provided the link for some federal guidance on these laws as well as state guidance, which isn't necessarily legally binding, but it helps sort of show you the direction that the law is moving. So every school has a responsibility to find students with disabilities in their district and ensure that they are being evaluated for special education services if it's suspected that they might have a disability and need special education services. The school, a teacher can make a referral for this, a guidance counselor, an administrator really, and a parent can also request this. I definitely recommend you do this in writing because there's a timeline attached to it. And that can just be as simple as an email. You can write a letter and bring it to the school, whatever's easiest for you. But I definitely would make sure that it's in writing. The school district is supposed to provide you with a consent form within 5 days, and the evaluations are supposed to be completed within 30. And the initial meeting about whether or not the child's eligible for services is supposed to happen within 45 days.
And that's school days or calendar days?
Those are school days. Good question. And often people are like, well, what is an evaluation and what are they supposed to be evaluating for? The law says the schools should be evaluating for all areas of suspected disability. And this is going to look different for different students. Generally, the practice is to do a school psychological evaluation and an educational evaluation pretty much for every single student. But if the student is having major behavioral problems, it might make sense to also do a functional behavioral assessment. If the student is having communication difficulties because of a speech impairment, it might make sense to do a speech language evaluation and maybe an assistive technology evaluation. If they're having trouble writing, gripping a pencil, having sensory issues, maybe an occupational therapy evaluation. And so it's sort of up to the school and the family to sort of think through what this child needs and what areas they should be evaluated in. And there's not sort of a one-size-fits-all model. So I definitely would encourage you to, if you just see the sort of standard check boxes checked, to think about what your child might need and what evaluations maybe the school hasn't considered yet, and ask for those specifically. And I actually have in Handout A the evaluation consent form. And you can see that there's actually a little line that you can request additional evaluations at the bottom. So be sure to engage in that dialogue with the school district, because sometimes I think school districts might overlook something that you're seeing. So definitely engage in that. Yes?
Sorry, is there a checklist of the types of things that they can assess for?
So they have sort of the standard Massachusetts form that most schools use, has educational assessment. It does have sort of a checklist of things on it, and the school can decide, oh, this doesn't make sense for this particular student, like a home assessment. Sometimes they're like, that doesn't make sense for this kid, so they'll check no for that. But if there's something, for example, a functional behavioral assessment isn't on here, an occupational therapy assessment isn't on here, so they would have to write that in. And if you think that's something that they need but haven't written in, then you can also ask for that specifically as a parent, or a school administrator can write it in as well. If they're like, I see, they're having trouble gripping a pencil, let's do an OT eval.
I could ask you more later.
Okay, fair enough. And here's the form here, sorry. And you want to make sure you keep a copy of that for sort of timeline purposes, to make sure that it's within the timeline, so you can keep tabs on that, because oftentimes schools are very busy and they lose track. So after the evaluations are done, the next thing is a team meeting. So this is a group of sort of school people and parent people that come together to decide what services this child needs in order to receive an education, or they decide that ultimately the child's not eligible for special education services. At every team meeting, it's required to have the parent there, a special education teacher, and a regular education teacher. A parent can sign a waiver for one of those. So for example, if you have a student with very severe cognitive disabilities that's in a very restrictive setting and not participating in general curriculum, it might not be necessary for a gen ed teacher to be there, and a parent can waive that right. But you can also insist that a gen ed teacher does come, because maybe they have something to say, or maybe there's a way to be more inclusive with that student. And any other school staff that the school thinks should be there can be there. The parent can also bring any support people that they would like to bring, even if that's grandma, that could be an outside therapist, that could be a doctor, whoever you want to bring can come to the meeting.
And do you need to inform the school that you're going to be bringing outside people to an IEP meeting?
I think that's best practice, yeah, just as a courtesy, I think it's, give them a heads up that this, the PCP is coming, or a lot of times doctors don't want to actually come in person, so you can get them on the phone, so you need to ask if they have the speakerphone set up. So just, I think the more collaborative, the better. You also, if you're a non-English speaker, have a right to translator at IEP meetings. That includes ASL translation, if that's what you need. And you have a right to have all the documents that are reviewed at the meeting translated into your preferred language, if you're a non-English speaker. So the next question that the initial eligibility meeting comes about is who's actually eligible for special ed services. Just because your child has been diagnosed with a disability doesn't mean that they're eligible for special ed services. Essentially, the question is, can they make effective progress in the classroom? Are they making progress? And that doesn't mean, are they getting A's? That also doesn't mean, are they getting A's, but they're getting in a fight every day at school. It's both academic and social emotional, and it needs to be both. The child needs to be making progress both socially, academically, and emotionally, behaviorally. And if those things aren't happening, then the child is likely eligible for, and it's due to the disability, the child's likely eligible for some special ed services. And handout B that I have, this is the chart that the state uses, and it sort of talks about the various, sort of goes through this graph in a more complicated way, the various disabilities, as well as, is the child not making progress? Are they eligible? And I think this doesn't, personally, I don't think this focuses enough on the social emotional, and that is, I think that makes it confusing for school districts, who I find sometimes do not provide students with IEPs who have social emotional issues but are doing well academically in school. But the child really needs to be making progress in both areas in order not to be eligible for an IEP. So if they're not making progress in one of those areas, they still probably are eligible and could benefit from some services. This is another area of confusion. There's a list of disability categories in the law. So those are the categories that the school has to place your child in legally, and this causes a great deal of confusion. Parents say all the time, my child's dyslexic, they've been diagnosed with dyslexia, why can't they just say the child's dyslexic on the IEP? It's like, well, they have to put them in one of these categories. And I think the strangest, most common example is health impairment, where everybody with ADHD is put under. It's sort of, because where else do you put them? So these are the areas listed under the law. So if your child is not diagnosed with these things, but this is what, under the law, they have to put on the IEP as far as a disability category. The school district can also elaborate and say they've been diagnosed by Dr. So-and-so on X date with A, B, and C, just for clarity. But they do also have to include one of these categories, or sometimes two. Sometimes they'll do primary, secondary. So that's an area of great confusion, I find.
Is ADHD always under health impairment, or can they put that also somewhere else?
They could put it someplace else, I guess. There's different, under the law, these each have statutory definitions, so they're defined. So if sometimes a child may be diagnosed with ADHD, ODD, a mood disorder, a bunch of things, and then maybe they consider a neurological impairment classification, or maybe if they're young, maybe a developmental delay. It's sort of if they feel like it meets the definition. And if you have a problem with the definition, it's something you can contest. Although I don't think in practicality it matters much what the specific label is. So an IEP under the law has to provide a FAPE, which means free, appropriate public education. What on earth does that mean? Nobody knows. It essentially, it means that the child needs to be getting meaningful educational benefit from their programming. So they need to be making more than de minimis progress. They need to be getting somewhere. Does that mean that they're getting all A's? No. Does that mean that if they're passing all their classes, that's enough progress? Maybe not. So it's sort of this amorphous thing that's hard to define, and it's going to depend on every specific kid. But essentially, they should be making progress towards their IEP goals, and things should be improving for them in school across, again, all those spectrums, whatever, socially, behaviorally, emotionally, and academically. So if they're showing regression in one of those areas of need, then maybe they're not in the right service, or maybe they're not getting enough of that service. If they're showing some progress, then likely the program that they're in, or the amount of service that they're getting in that area is appropriate. So there's no sort of a one-size-fits-all, and it's a little wishy-washy. The other definition that confuses everyone is LRE. What does least restrictive environment mean? The law has a preference to keep special education students in with general education students as much as possible, and access to the general education curriculum as much as possible. And this comes from sort of the day of institutionalizing everyone with a disability. Found out that was not a good way to go. And so now there's a preference in the law to mainstream students as much as possible and give them the opportunity to have access to same age peers, to have access to, the lunch, the hallway, all those things that are sort of a little bit intangible about going to school. And, but they also at the same time need to be able to have meaningful educational benefit from their program. So there's sort of a balance between those two things. And this is the spectrum of, or continuum of placements that school districts need to provide. This doesn't include, charter schools also have to provide special ed services. They're considered a public school. And the regular education classroom, it would be full inclusion. Sometimes that means there's a special ed teacher in that classroom, but they have a gen ed teacher and there's other gen ed kids in the classroom. It also can be a regular education classroom, maybe with pull-out services. Maybe they just have speech 2 times a week, but the rest of the time they're in regular class. And then a substantially separate classroom would be a smaller classroom that's like a pull-out. That could be for part of the day or the whole day with a special ed teacher only. So there's no gen ed kids in that class and there's no general education teacher. It's just a special ed teacher with only special ed students, but you're in a regular school building. A step more restrictive than that would be you're in a special ed school in a special ed class with a special ed teacher. So you're like sort of segregated entirely for some type of program, or there's some need for a smaller environment. Some kids have sensory needs that can't, be met in a regular school because the hallway's too noisy, they're too overwhelmed. It can, for a variety of reasons, a child could need that. And residential is the most extreme, where a child has their sort of emotional, social, and academic needs are so intertwined and they need 24/7 care. That can also look like, as on the extreme end, hospital care where you're getting your educational services because you're medically fragile in a hospital. So those are sort of more rare and more extreme, not likely to see those sort of day to day. And so how do you know what program your child's in? A lot of times parents, when I talk to them, can't even really describe what exactly program their child is in. This is the service delivery grid. It's incredibly confusing. Ask a lot of questions about it. I think the easiest way to go through this with a school is to get your child's schedule, their actual classroom schedule, and go through the service grid and have the school explain to you what is special ed about each class and what's not. So their PE class, all right, they're in a general ed PE class, all right, I understand that. What about their reading and writing class? What's happening there? And the school will say, oh, they're in a pull-out group for that. And you're like, okay, where is that on the grid? The first grid, grid A, is just consultation. So anything in that A grid is not a direct service to your child. That's a service between staff members. So essentially, it could be the OT and the special ed teacher talking about some sensory needs of the child and working together. Or the BCBA, whatever it may be. So that's not an actual service that your child is receiving. In the second grid, grid B, is special ed services that are being received in the general education classroom. So those are sort of, I like to think of them as push-in services. So the child's in a regular classroom, but some sort of specialist or special ed teacher is coming in to provide a service in the classroom. And the last one, grid C, is pull-out services. So you're outside the classroom with a special ed teacher, not with regular ed kids. Every school does the minutes differently depending on the school schedule. It gets very confusing. So I think like having the school walk through the child's schedule and matching it to the service grid is a great way to figure out exactly what services are being provided to your child day to day. Because it does get very confusing, and oftentimes, even though I've read a lot of IEPs, I have a hard time understanding it without the context of the schedule. So I find that to be helpful for clarity for everybody. Oh, sorry. Yes.
Yes, could there be a parent consult in grid A?
There could be, if that's something that the team feels that the child needs in order to make progress. I think the more likely scenario is the school doing like a home communication log. But you could put something in there about doing a consult with the parent, but the school has to balance that with sort of the teacher's time, the resources. So it would depend on sort of how they would best want to go about that.
If there was a home communication log or a daily log that goes home, should that be in the A grade?
That would not. That would just be probably considered either a combination or in the notes, or it'd probably be listed someplace else, not in a grid. This is just for services. So this is just sort of, well, the consult grid is for between sort of professionals, but the grid B and C are just for like services. So a person providing a service to your child. Accommodations are slightly different.
Could it be a paraprofessional or?
Yep, a paraprofessional is any sort of a person giving a service. So yeah, paraprofessional will be listed. Most likely it would probably be a push-in in a general classroom, so they would be listed in grid B. Unless it was in a sub-separate classroom, then it would be in grid C as a one-to-one, or if it's a classroom para, it doesn't necessarily need to be on the IEP because it's not that child-specific service. It's just a classroom para providing help to everyone.
If your child is getting services but doesn't have an IEP, should you get a similar type of grid, like for example, if they have a 504?
So she's going to speak a little bit more to that. It's a little different. Yeah, the rules are very different for 504, which just adds confusion to everything. And they don't have as rigid timelines and renewal periods, so it's just a different ball game. And it wouldn't be this grid like this. And they don't get special ed services. It's just accommodations on 504 plans, so it's a different ball game. So this is just services can pretty much be anything that a child needs to make progress, and so schools and parents can be as creative with that as they want to be. These are just a list of things that I've seen on IEPs that have been helpful to students. But if there's another service that is unique to a certain kid that they need to make progress, then that certainly can be included in an IEP. There's not like it has to be one of these things. It can be whatever the child needs in order to move forward. And I'm sure some of you had dealt with an IEP in the parent response form, which is on Handout D. There's 3 options that you have. You can accept the IEP as developed, which means, yes, I love everything. I agree to all of it. Hooray. I reject the IEP as developed, which means I hate this. Everything about it stinks. Most people don't actually feel like that way about it. Usually if they have an issue with it, it's a specific portion of it. So I often recommend to parents to pick the final one, which is I reject a portion of this IEP, and then attach a letter that specifies the issue that you have and why, and request to reconvene to talk about it. Because when you just reject the whole IEP, essentially the school cannot implement the new services that might be on that IEP. It will revert back to the old IEP until the new IEP is resolved. So I find that being specific about what you're rejecting is a lot better, because there probably are some services on the IEP that you want to continue or engage in that are new.
Sure. Is it true that you can also reject the absence of services? So, for example, if you think maybe your child needs a speech session, but that didn't end up on the IEP, would you check that 3rd box to reject the omission of speech services?
Yep. Yeah. If that's an issue you have and you think that your child is not going to make progress without speech services, you definitely can do that. I also would recommend requesting an evaluation for that if that hasn't happened, which again, it goes back to that same evaluation timeline. They have to conduct the evaluation. If the school already did conduct an evaluation and the speech therapist that they hired or have in district said, no, your child doesn't need speech services, you can then request an IEE or an independent educational evaluation from the school, or just go outside out of pocket and get your own evaluation and come back to the school with a second opinion about whether or not your child needs those services. The second page that everyone signs is on Handout E, the placement form. This one is, you're either accepting where they're placing your child or you're not. This just really, I think, is helpful to show what type of program your child's in. So this usually tells you sort of, is it full inclusion, partial inclusion, substantially separate, sort of get a better idea of how much special ed they're receiving sort of in a big picture way. And you can also request to meet with the school about this. A lot of parents get confused and think that this means that they can disagree with the physical school building that the child's being placed in. So say there's school A and school B, and you really want your child at school A, but they're placing the child at school B. You can't really pick and choose what physical building the child's in. What you can reject is sort of the special ed program placement. So you can say, I want my child in full inclusion. I don't think they need this level of service that you're providing, or vice versa. I think my child needs more special ed services and needs to be pulled out more. And so you can reject it like that, but it's not rejecting the actual physical building that they're placed. The school district has discretion to sort of place students in whatever building based on their school policy. So there's some confusion often around that. I don't know if I see some confused faces. Does that make any sense? Okay. Oh, that's placement form, sorry. So schools, once your child has an IEP, now what? The school is obligated to do at least an annual review. So they have an IEP team meeting. So all those people that got together at the initial meeting have to get together again every year and renew and update the IEPs. So you want to look at the goals, whether or not they're making progress. You should be getting progress reports about the IEP goals every time your child gets a report card. So every time they get a report card, you should get a progress update about whether or not they're meeting their goal or goals on their IEP more often than not. And those goals should be objective and measurable. So if you're getting a progress report that says in a reading goal, and it just says he's improving his reading, that's not specific or measurable, and it's not telling you whether or not he's meeting the goal. And the goal should also be, specific and measurable as far as, he's going to be able to identify sight words in 7 out of 10 trials, or 7 out of 10 times or something like that, or get 80% on this. However they want to do it, it has to be measurable in some way, so that way you can kind of keep tabs on it at home. Are they actually making progress towards this or not? Yes.
With the progress report, so in the upper grade, like middle school and high school, you get your grades electronically. Is there a time frame that they have to abide by getting you your progress report in the mail?
So they're supposed to issue them, there's no time frame, but they're supposed to issue them when they issue report cards. So maybe they're not doing the progress reports electronically, but they should mail them to you around the same time that you get the electronic report cards. But if you're not getting them at all, then that's a problem. If you're getting it just 2 weeks later, then I would say that's probably fine. If just because there's only supposed to be one annual review every year doesn't mean that a team can't meet more often. If there's a problem, request an IEP meeting. If there's regression, if all of a sudden a student who was doing okay, getting a mixed bag of grades, all of a sudden falls off the boat, starts failing everything, or getting in a bunch of fights, request an IEP meeting, and the school has an obligation to ensure that they sort of are providing the right level of service. If the service level the service needs of the child change, then they need to change the IEP. So definitely, I encourage people to be proactive about that and work collaboratively with the school. Some ambiance. Yeah. Everyone's asleep. And a school has to reevaluate as far as doing that whole series of evaluations at least every 3 years. But again, if the needs of the child are changing or they've been diagnosed with some new disability, or an outside professional thinks they might need some service, then request that evaluation in between those 3-year periods. There's nothing stopping you from requesting an evaluation if a need arises. The school is just obligated to, on their own, do at least an evaluation every 3 years. And often schools are willing to push that up if there is a problem. If a child is struggling, they're willing to sort of push that up and do a whole new hash of evaluations, say, at year 2. Sure.
So what if the child is initially rejected for having an IEP, is put on the 504, if failing in the 504, can you then ask for another evaluation, and what time period would that be to get them qualified to be on IEP?
So if they just did evaluations and they found the child not eligible, your best bet would to be go through this IEE process as opposed to asking them in the same, if you're asking them to do evaluations in the same year, they don't need to do that. There would need to be like sort of a change in situation, and the school would just say, you know, we just did these evaluations, we came to a conclusion, you can, you know, fight us on this as far as exercise your rights at the Bureau of Special Ed Appeals if you'd like, but your best bet would probably be to get an independent educational evaluation, and you can request that from the school. So essentially you have a right to a second opinion, and the school has to provide you with a list of providers in the area that provide the same sort of evaluations that they conducted. And then you have to find an evaluator that takes the state rate, which is the tricky part because no one takes the state rate. They need to update the law. So, and you sort of have to exhaust that and call them all. I had a school district recently send me 141 providers that allegedly did functional behavioral assessments with the BCBA. I had a poor intern call all 141. Not one single person accepted the state rate. But I had to exhaust that to go back to the school to say you need to do above the state rate. So it is a process. In Massachusetts, I think sometimes it's easier to go through your health insurance to get something like a neuropsychological. If you're on Mass Health, often Mass Health will cover that for a child. Other insurances do as well. Or if there's a specific sort of other need, that's might be a route to go. It's a little bit easier for things like speech evaluation or OT or PT evaluation, but again, you're going to have to do that sort of state rate whole hullabaloo, which is difficult, and it's a process. And there's a sliding scale for fees, so if your child qualifies for free or reduced lunch, then that independent educational evaluation is paid for by the school in full. After that, it's sort of this complicated sliding scale where it's a cost share. And then at a certain point, if your family income is of a certain amount, then it becomes fully, the parent has to pay for the IEE. My clients are low income, so that's not something that I don't know sort of the other end of the scale, but I do know like sort of basics. It gets very complicated, and yes.
In your experience, have you found that the results or conclusions drawn by an IEE person is generally more favorable than those found by the school?
I think it really depends. I think a lot of times a school district may have a lot of really good recommendations but not be willing to provide a service. So, for example, with a lot of my clients, I think that they would benefit from direct BCBA services, but very few schools are willing to provide that to students without autism. And so sort of to get a different perspective to say, no, actually this child would benefit from a behaviorist or a BCBA a couple times a week working with a special ed teacher to come up with a really robust behavior intervention plan that's actually going to have the student make progress towards this. So sometimes that's helpful. Other times you find, I feel like it's worth asking, right? If you think the child needs a service, it's worth getting a second opinion about it. And if the outside evaluator, I've had that happen where the outside evaluator says, no, actually we think what the school's doing meets their needs, and that's fine. But at least then I feel like it's sort of a little bit of peace of mind as far as, oh, okay, well, like if two people say this, then, you know, at least you feel a little better about it. So the IEs can get a little complicated as far as logistically how they work.
So what if someone does do their IE and say the school does a speech test and they say, nope, your child did great, we don't need a need for service, then you have an IE done, and they say, you know, we see a problem here and we think they require service. So you have conflicting results on testing.
Yep. That's what will happen, and then you have to come back to the school district and have a meeting, and hopefully can convince them to give some service. If the school district still says no to you, now you have an expert witness, and you have an evaluator that's saying they need the service, and so then it becomes sort of a battle of the experts at the next level at mediation or at a hearing. So if the school does continue to say no to you, you can exercise those rights. But I wouldn't go down that path without an expert on your side. Unless you're going to mediation is a little bit more, you don't necessarily need an expert for that. But if you're going to go to a hearing, you definitely do. So I don't know, I know school discipline's what I do, but I don't know if anyone here has actually any questions. I want to sort of, there's a lot of 504 questions. Discipline's confusing. I feel bad for schools, honestly. There's a lot of different laws for different levels of students. The big sort of takeaways are to know what counts as a suspension. Anytime a student's excluded taken out of their regular programming for more than half a day for a disciplinary reason, that's a school exclusion. Schools can say they're going to like a therapy room, they're doing this, they're doing that. If it's not a service on their IEP grid and they're being taken out of their classroom or sitting in the principal's office, it should be a suspension. Calling in the younger grades, can you come pick them up? Can you come pick them up? In the older grades, sometimes they just send them home. Those should all count as suspensions, and there should be a paper trail. Yeah, that's. Massachusetts also has its own school discipline laws for all students, so they apply to both general ed and special ed students. Generally can't exclude a student for more than 90 days. Sadly, there used to be no limit. You have a right to every student has a right to some education while they're suspended. You have a right to a hearing with the principal for any time a child's suspended. Again, this is general ed or special ed students. And if it's a longer than 10-day suspension or there's been 10 individual days of suspension throughout a school year, you can appeal to the superintendent for that suspension decision. So this is sort of how it works as far as what the different rights are. But essentially, prior to 10 days, you just have a right to sort of do your makeup work, make some progress, and after the 10 days, the school has an obligation to provide you sort of with a little bit more than that. Usually that's an online programming or tutoring. And this applies to all students. And there's a handout actually that another attorney that works at GBLS put together that I think really explains this well if you find yourself in any sort of discipline scenario. Then it's further complicated by the special ed laws, which say that after 10 days, a student has a right to a manifestation determination review and also has a right to continue to make progress towards their IEP goals while they're out of schools. Providing tutoring or online programming for most kids with special ed services is not sufficient, and they usually need more than that. So that's an area that you can sort of push back on the school to get kids back into school faster. Because if they have sort of extensive IEP services and all they're getting is an online program at home, that's probably not sufficient for them to make progress towards their IEP goals. Or if they have a goal that's working on socialization or behavior in the classroom, well, if they're not in a classroom, how are they going to make progress towards that? This is where I live and breathe. And that you also have a right to a manifestation determination review, where essentially the school needs to determine, the IEP team in particular needs to determine whether or not the child's conduct was related to their disability. So if there's sort of a nexus between the child's disability and how it manifests and the child's behavior, the school can't suspend them for beyond 10 days for that, because the idea is you shouldn't be excluding someone for their disability. If you have Tourette's and you're cursing all the time, that's a violation of the school code, but you're not going to keep suspending the student for that. They can't help it. And that's a very basic example, but you can extend that to sort of students with PTSD. Sometimes they have dissociative episodes, and they're being pushed out for long periods of time when really it's sort of a manifestation of their disability. And these are the questions that they ask at a MDR. I'm not going to get all into the details because I think some more 504 questions here. I've sort of referenced this. If you're having behavioral difficulty with your child, definitely ask for a functional behavioral assessment, and the school should be developing a behavior plan to help the student have an individual sort of their own thing to help them. Just a quick word about bullying. The law doesn't help. It's a problem everywhere. Schools are required to have a bullying prevention plan, and usually it's on their website or you can ask for it. Schools are required to investigate any incident of bullying. So if you think your child is being bullied, I definitely would get as much detail about the situation as possible. If that means, especially for older kids, if you can take screenshots of social media, video game chats, whatever it may be, and actually provide that to the school, and this is going on during the school day, or it's coming into the school, the school has to investigate it. They have to sort of tell the parent what they're doing to stop the bullying, so maybe they'll create sort of a safety plan, maybe they'll change classrooms for kids. What they don't need to tell you is whether or not that other child was punished for the behavior, because that's private information for that child. They can't say, oh, Johnny was suspended for teasing Sally. They can't tell you that. So parents get frustrated with that, but that's to protect the other child's privacy rights. And if it were your child who was getting suspended, you probably wouldn't want the school telling everyone either. So, and if your child is being bullied, they also can, and the child has an IEP, they also can sort of make a goal towards self-advocacy or working on how to cope with bullying in a better way or a more productive way, or sometimes just working on social skills. Sometimes kids who are bullied just don't have great social skills. So that's something that you can also proactively say, well, if this is something they're struggling with, we need to do something with this and make a goal about this. And that goes the same if your child is the bully. If your child is bullying other students, there's probably a reason for that. And if they're on an IEP, they could be overcompensating for something. There's a million reasons why. But if they're not handling their emotions appropriately and need some help in that, that's also something that the school should be working towards in their IEP. If there's compliance issues, so I say compliance issues, if there's issues with timelines, if there's issues with sort of very black and white regulatory violations, then you can reach out to the state PQA agency, which deals with sort of state complaints about violations of both federal and state laws, but they're not great for sort of gray area issues. If on your child's IEP it says that they're supposed to be getting speech twice a week, and the speech teacher went out on maternity leave and they haven't had any speech since the teacher left, that's something you can write to PQA about, and you'll probably get comped for those services. But it has to be like very black and white like that. PQA is not great for gray areas like, I think my child needs 4 sessions with a reading teacher every week and the school's only giving me 2. They're not going to be helpful with that. They're just going to say, it says 2 on the IEP, are they getting 2? But if you requested evaluations and it's been 4 months, they'll be helpful with that. If you requested records and you haven't gotten them and it's been a month, they'll be helpful with that. Suppose you have access to records 10 school days. And again, in your main language. So there's sort of like a ladder of disagreement levels. The first one is sort of just informal conversations, emails, a collaborative process that I'm sure you all have engaged in with the school.
Can I ask a quick question back on that other topic?
Sure.
So what if your child isn't telling you that they're not getting services? They don't come and say, I had speech today. So what's the school's responsibility to tell you whether they're actually providing them, or if they have a tutor, or if it was, a substitute, or?
Yep. So, if it's for something like speech or OT or PT, there should be sort of a service log, and when you can request your child's records, and you can specifically request that service log that'll say what days your child actually had speech and with the providers.
How frequently could you request that? Let's just say that was an issue. How would you tackle it? Is it reasonable to say every Friday send me home? This has been historic, it's not happening, he's not getting the services, you're not telling me about it.
If it's been a problem in the past, I think you can try to work out something with the school where they are sending it on a regular basis. If they're willing to do that, they don't necessarily have an obligation to do that. But you could also periodically, maybe like, once a month, request the records and just be very specific about that. If, very specific thing that you're looking for, and you're not asking for the child's entire record that's kept in the 4 schools the child's been in or whatever, just this specific thing for the last month. You can do that, and the school should produce that within 10 days. The other thing that I encourage parents to do is there's a DESE lookup. You can look up licenses. So sometimes teachers are not certified in what they're teaching in. So sometimes you have a special ed teacher, but they're not actually a special ed teacher. So you can look up their licenses right online. Sometimes schools do have waivers, though, so you can ask the school about that. So sometimes it's cleared with the state that the person is teaching outside their certification. So you would want to double check that. But sometimes you find that you'll have a teacher who's not a special ed teacher teaching a special ed class, which is a little concerning.
Where do you look that up?
It's on the state website, DESE, Department of Elementary and Secondary Education. And if you I find their website's very hard to navigate. But if you Google what you're looking for and just put DESE, it comes up. So if you just say DESE licensure lookup, it'll take you to the page, and then you can see where it is. And then you just type in their first and last name. If they have a super common name, then you're kind of you're just like John Smith. You're like, good luck, because there's probably a million. But and it doesn't tell you necessarily what school districts are in. But if they have a semi-unique last name, you usually can find them. And this is just sort of the level of that you can take things when you disagree. Again, that common level that everyone's on, and then. Mediation, which I really highly recommend if you're having a big dispute with the school. The mediators at the Bureau of Special Education Appeals are really great. I interned there in law school, and I sat in some really productive mediations. I think if you're willing to compromise on some level, and the school district is willing to compromise on some level, you will come to an agreement there. After that, where I put sort of the red line, I would say that's sort of when it would be useful to get an attorney involved if you're getting beyond that point. You do have a right to go to the Bureau of Special Ed Appeals alone, pro se, as they say. And you can do a resolution session, settlement conference, and then ultimately a hearing. But I do think that's very difficult to navigate without an attorney. So I have cards and other information. I'd be happy to answer any questions, but I know there's lots of questions about 504, so I want to give some time.
Do you recommend an attorney for mediation then, or just for when you get to that next level?
Oh, yeah. No, I think mediation actually is much more productive without an attorney. Mediation is meant to be sort of everybody coming to the table and having a third party objectively say, okay, well, this outside evaluator is saying they need three sessions of speech. The school district one's only saying 1. Can we settle on 2? And try to come to some sort of agreement by having a, sorry, not talking to the microphone. And I do find that they're very skilled at what they do, and 2 parties come in like miles apart, and they can often come to some agreement. Maybe they won't resolve everything, but they'll resolve some big issues and at least move things along.
All right, perfect. So hopefully you all can hear me. I am advance warning condensing what's typically an hour and a half to 2-hour presentation, as my colleague did here as well, into 20 to 25 minutes. So bear with me. And if I run over, please make me stop. Again, my name is Nicole Murhill. I am a civil rights attorney. I've been practicing in the area of civil rights for 16 or so years now. In that time period, I worked for 14 and a half years at the U.S. Department of Education Office for Civil Rights, handling cases involving race, color, national origin discrimination under Title VI, disability discrimination under Section 504, gender-based discrimination under Title IX, and the Age Discrimination Act. Today we're talking about 504 Title II.
Presently, I focus on Title IX issues, which has kept me rather busy for those folks who've been following the news. In any event, today we are going to be talking about 504 and Title II. I'll speak about 504 generally, but typically when looking at discrimination cases, the language of the statutes in Title II with regard to elementary and secondary education and 504 are quite similar. So let's have a look at 504. So the statutory language is pretty simple and states that no otherwise qualified individual with a disability in the U.S. shall solely by reason of their disability be excluded from participation in, denied the benefits of, or otherwise subjected to discrimination under any program or activity receiving federal financial assistance from the U.S. Department of Education. Basically what that means is any school, elementary, middle, high school, and post-secondary institution, now we're all wide awake, anyone who receives federal financial assistance must comply with Section 504. Why is this really important? Because this law follows the child through elementary school, middle school, high school, and on to college. So when you lose your protections under IDEA in the post-secondary context, Section 504 stays with you. So that's a very important takeaway. The basic obligations that we'll cover today relate to location and notification, that FAPE standard, free appropriate public education. You'll see many, many overlaps between IDEA and Section 504, but there are definitely key differences that we'll touch on. Section 504 also covers non-academic services, so we're talking about field trips, after-school activities, all programs and activities operated by the school district. Procedural safeguards, obligations on the part of the school district to let parents know what are their rights. School districts are also obligated to have a Section 504 coordinator identified, and they are obligated to develop a system of procedural grievance procedures. So the first piece here, location and identification, this is akin to the child find provision under IDEA. So here's one area where there's a pretty direct overlap. The burden is on the school district in the elementary, middle, and high school context to identify and locate every qualified individual with a disability who resides within the district's jurisdiction. The burden is not on the parent to make the referral of the child. The burden is on the school district. So if the teacher is noticing that a student is having difficulties in class, is not keeping up with their peers, the obligation is for that teacher to reach out to the requisite staff, whether it's their local 504 coordinator, their special education person in their school, and initiate that referral process. Schools are also obligated to respond to parental referrals, which is a key piece too. Sometimes school districts aren't seeing the problems and challenges that you're seeing at home. It's really important for you to let schools know that. So you might have a student who is apparently doing really well in school, they're getting really excellent grades, straight A's, and they come home. I use this example all the time. They get home from school and they are sobbing because it took every single ounce of their being to make it through that school day. And then they're up all hours of the night trying to make it through their homework assignment, to make that assignment perfect, to complete that work. To the school, it is a student who is having no issues. Unless you share with the school and convey to them what you're seeing at home, the school wouldn't know to make that referral. So the parent is a really critical piece to that evaluative data, the parent's experience. Beyond that, the notice requirement here, very similar to IDEA. Most school districts either have a session like this today where the school lets folks know of parents' rights, or they publish in a newspaper. I don't know if schools do that anymore. That's like my generation. Maybe it's online on the website, but they have a identification location obligation. The standard under 504 is FAPE, so free appropriate public education. And who is a qualified individual with a disability? I say this pretty frequently because I think it's a mistake that school districts oftentimes make. And that is, if you evaluate a child for an IEP and the student is not eligible for services under IDEA, 504 is not the consolation prize. Okay, I will repeat that again. If they do not qualify for services under IDEA, that doesn't mean that they get a 504 plan. There is a separate process that a school district is obligated to follow to determine whether or not a student is eligible for services under 504. It is a separate law, it's a federal obligation, and the school district must have a system in place to conduct those evaluations for eligibility. So who is a person with a disability under Section 504? So it's a person who has a physical or mental impairment which substantially limits one or more major life activities. And we'll break that down into a couple of different pieces and talk about how that differs from IDEA, because I think this is the biggest area where there's a difference between IDEA eligibility for an IEP and 504 eligibility for a 504 plan. I'm not going to focus today on the record of impairment or regarded as impairment because we just don't have the time. But if you have specific questions about that, I'd be happy to answer them. So let's talk about a physical or mental impairment. What is a physical or mental impairment? It's a non-exhaustive list here, right? So it could be a neurological issue, respiratory issue, cardiovascular, digestive. It could involve skin, the endocrine system. And so important takeaways here are we're not just talking about major life activity of learning. So when we are talking about the endocrine system, we're not talking about learning, we're talking about endocrine functioning. When we're talking about the respiratory system, we could be talking about breathing. So there's a large population of students who may not be eligible for services under IDEA because the key touch point for IDEA is learning, but may qualify for services under Section 504 Title II because the major life activity impacted is, let's say, caring for oneself, breathing, learning, hearing, eating, reading, thinking, communicating, major bodily functions. So a school, when determining eligibility, needs to go through each of these steps of the process. Is there a physical or mental impairment? That's step one. Is there a substantial limitation on a major life activity? And the school district must be looking beyond the major life activity of learning. There are students who are on 504 plans who are in AP classes, who are getting straight A's in AP classes, and are still eligible for services under Section 504. The example that I always use is a student, let's say, who academically does very well but has a severe injury to their back. And so they cannot sit for more than 45 minutes without having a break and standing, or they need to have a standing desk to do their work. That student has a physical impairment, their back injury, whatever the diagnosis for their back injury is called. It substantially limits the major life activity of standing. They can't sit for an extended period of time. So if the student isn't given a plan that addresses their individual needs, to have rest breaks, a standing desk, breaks during exams, they in all likelihood would not be able to pass an AP exam or maybe pass the course for AP. But what are we testing? Are we testing a student's ability to sit for an hour-and-a-half exam, or are we testing their knowledge in the subject matter? We're certainly testing the knowledge in the subject matter, so that's why it's critically important when a school is conducting an evaluation that they know what major life activities that they're considering. A couple points here to add before I move on. An area where I oftentimes saw schools make mistakes beyond focusing solely on learning are areas that are seen as medical conditions. So students would be placed on a health plan and not a 504 plan. Why does that matter? Some schools would say, well, that's okay, they're getting the services that they need. Well, when things go wrong, if there's a disagreement, the parent wants X in the plan, the school district doesn't agree with X or thinks Y should be in the plan, the parent has no recourse under a health plan. Under a Section 504 plan, you have processes in place that protect you as a parent. You can proceed to PQA at the Mass Department of Elementary and Secondary Education, and you can argue that the plan isn't being implemented. So if the plan calls for a student's blood sugar to be tested 15 minutes before lunch, right before recess, if the student is diagnosed with type 1 diabetes, and the school isn't doing that in a health plan, there really isn't a recourse. In a 504 plan, if those blood sugar tests aren't happening, if the student has a very high blood sugar and the 504 plan says when a student encounters a high blood sugar, they are not required to take an exam within a 24-hour period, and the student is required to take the exam, on a health care plan, there's no recourse. In a 504 plan, if the school doesn't adhere to the plan, the parent could, of course, we would encourage the parent to let the school know, to reconvene the team and work together to resolve that concern. But if you can't resolve that together, you have the option to go to PQA or to the Office for Civil Rights and file a complaint. So what about a substantial limitation? This is the most challenging area. There is no definition of a substantial limitation. People always ask me, how much is enough? What makes a student qualified? What should be considered? Well, the evaluative data is what's used as a guide as to whether or not the impairment is substantially limited. In reviewing medical type cases, I'll use asthma as an example, that often comes up. It's a physical impairment. We're looking at, is there a substantial limitation on the major life activity of breathing? I think I used this example last year when I was here. What I would do is I'd go into the school district's nursing logs, and I'd look at how many times that student visited the school nurse. And for some kiddos who were diagnosed with asthma, they went to the school nurse once. For other kiddos, they went to the school nurse twice every single day. So every single day they were leaving the classroom, so leaving the educational setting, because they were struggling with breathing, and visiting the school nurse. That's one indicator of whether or not there's a substantial limitation on the major life activity of breathing. The evaluative data provided by the medical provider in the case of asthma would be a guide as well. What are the teachers seeing in the classroom? So if we're moving away from the medical realm and into a mental impairment, what is the teacher seeing in the classroom? What is the parent seeing at home? What does the evaluative data say? Under IDEA, there's typically that form. People talk about the core evaluation. You might see a Woodcock-Johnson, a WISC, an OT, a PT, but do you need all of that evaluative data if you're talking about a kiddo who is diagnosed with asthma? Do you need that evaluative data if you're talking about a kiddo who's diagnosed with type 1 diabetes? Not necessarily. There isn't a specific checklist of evaluations that you use under Section 504. What should happen is the team convenes, talks about what's going on with the particular kiddo, and they discuss as a group what evaluations make sense in light of the student. And I oftentimes call it a soft evaluation. So your evaluative data might be, what is the teacher seeing in the classroom? What is the parent seeing at home? There may be a Connors assessment. There may be a speech assessment. There may be a neuropsych that a parent did independently thrown into the mix. You may have a full core evaluation. It's perfectly appropriate for a child to go through the IEP process, be found not eligible, and then go through the 504 process. What's important, though, is that when you're taking that evaluative data that's gone through the IEP process, to thoughtfully consider, what are my questions here? 1, is there physical or mental impairment? 2, is there a major life activity impacted? And 3, is it a substantial impact on a major life activity? So team process, here is a key area where there's differences between 504 and IDEA. Someone asked earlier about the grid and whether there's a grid required for 504, and the answer is no. In fact, the regulation is very thin on what is required to be in writing. It says that information that's considered as part of the team process must be documented and carefully considered, and that's it. So there's no requirement, even in the regulation, that says a 504 plan must be in writing. So I oftentimes hear from parents, well, the 504 wasn't on this special form or that special form, or didn't include a signature block. There's nothing under Section 504 that says a plan even needs to be in writing. Now, from a practical standpoint, good luck to a school district that has 75 kiddos in one school on a 504 plan trying to implement. So I've never seen a school, quite frankly, that doesn't put their 504 plans in writing, but they can take a variety of shapes and forms, and that's okay, as long as what's documented in the form is clear enough so that when the folks leave the team meeting, the persons who are responsible for implementing that plan understand how to implement it for that student. The other piece is making sure that the placement decision is made by a group of persons knowledgeable about the student, knowledgeable about the evaluative data, and knowledgeable about the placement options available. So make sure if you're reading a neuropsychological evaluation or you're reading some other medical evaluation, maybe you need the school nurse as part of the team meeting. Maybe you need a special educator as part of the meeting. Not all team meetings need to be made up of the same people. So in the IDEA world, you have to have certain people in attendance at a meeting. So there's a checklist, and parents must be included in the IDEA process. Now, schools can make reasonable efforts to include parents in IDEA, and if they attempt to conference call parents in, change meeting times, and the parent still doesn't participate, then the school can proceed. 504 does not have a strict checklist of who must be in attendance. It really should be a thoughtful deliberation among the persons about who is most knowledgeable about the student and the evaluative data. Parents are not required participants in the 504 process. Now, best practice, again, is to include parents in the process, because when you ask the question about who is most knowledgeable about the student, the parent is clearly going to be one of those persons. If a school is having challenges with a parent and decides not to invite the parent because they're challenging, they can't say, aha, but we're not required to invite the parent. Okay, that would be called retaliation, and that's prohibited under Section 504. So if the school's practice is to invite parents, and most school districts' practice is to invite parents, they cannot use the absence of a parental obligation as a basis to exclude the vocal parent.
Can I say one little piece
Of
about
course.
eligibility? Sorry. So she was mentioning earlier about this impacting substantial life activities. If your child went through the IDEA process and they found that they're not eligible, but then they're going through this 504 process and they're saying that the disability is impacting their learning, I think that to me says that then they're probably eligible for an IEP. If the disability is impacting learning and they're not making progress, then if they meet the FAPE standard, not the FAPE standard, if they meet the eligibility requirements under IDEA, then they're eligible. The 504 is a separate process, and it's, as she said earlier, not a consolation prize. So it's like, it's not supposed to be a compromise. If they're eligible, they're eligible. And then they have to go through a separate process. But if the team is saying that it's impacting learning, I would question that eligibility determination for sure.
So that then begs the question, why is learning included under Section 504? And the reason why is because all students who receive protections under IDEA, so all of your kiddos who are protected because they're on IEPs, are also protected by Section 504 as a law. They're also protected by Title II. So not only do you have the option of going to PQA, should there be an issue with implementation of the IEP, not only do you have the option to go to the Bureau of Special Education Appeals if there's an issue with implementation or a team dispute under IDEA, but you also can go to the Office for Civil Rights regarding concerns about implementation under IDEA. The regulations specifically have a provision that state something to the effect of implementation of a plan that was developed in accordance with the Education for All Handicap Act, which was the old name of the IDEA, is one means of complying with Section 504. You flip that around, failure to implement a plan developed in accordance with the IDEA, in essence, is a violation of Section 504. So that's the reason why under Section 504 you see the category of learning. But look at the distinctions between eligibility. Under IDEA, you're looking at the 13 categories of disability and where the student fits in on those labels. You're looking at the impact of learning. Under Section 504, you're looking at, is there a physical or mental impairment which substantially limits a major life activity? So there's a difference. The other piece under Section 504 that's a distinction is timeframes. So while we have timeframes, specific timeframes around notice, specific timeframes around evaluation, Section 504 does not have those specific timeframes. So you may request an evaluation of your child under Section 504. If you don't hear back from the school in 10 days or in 20 days, that is not necessarily a violation of Section 504. There's a reasonableness standard that's imposed. The cases where I've seen where there have been problems is when the parent makes a request, the school doesn't respond, and then we're several months down the road and the evaluation process hasn't started. That is clearly problematic. Okay. So once the placement decision is made, then the key is to implement the plan. Similar to IDEA and kiddos who are on IEPs, if the plan isn't working, reconvene the team. So we shouldn't be waiting for a complete downward spiral where you see the child, the plan is working the first 2 months of school. By December, child is starting to fail their classes or is withdrawn, getting great grades, but completely withdrawn from their peers. So this isn't solely about academic performance. If they're no longer socializing, they're completely isolating themselves, they're asking to not go outside for recess, they're no longer participating in the after-school activities. Those are the things that should trigger the reconvening of the team process. Evaluation. Here's another area where there's a distinction. So there's an annual evaluation requirement under IDEA and a full reevaluation every 3 years. There's nothing in 504 that has the parallel. It is best practice to follow your guidelines under IDEA for 504 students. Where I see school districts going awry in this area are they place a student on a 504 plan in 3rd grade and the team doesn't convene again until something goes really wrong freshman year. And then we're working on a 504 plan that is now how many years old. So the team best practice meet annually, full reevaluation every 3 years, or at critical junctures. So when the child is moving from elementary school to middle school or middle school to high school. And what the team should be talking about is the entire program and activity for the student. So not just academic programs, but let's talk about field trips. I had a conversation with a friend of mine the other day whose son was recently diagnosed with type 1 diabetes, and I said, why didn't you call me? We could have talked through the process. Please tell me your child is on a 504 plan. And he said, don't worry, Nicole, we have a plan, we're good to go. And I said, excellent, I'm really happy. And he said the school is doing great, not in Massachusetts. He lives down in the South. And I said, okay, what about field trips? And he paused, and he said, oh, I didn't really think about that. And I said, okay, well, what is the plan for administering insulin? What happens if there's an emergency? And he said, well, the school nurse is full-time now, so we're good. I said, is the school nurse going on field trips? And he said, oh, well, I didn't think about that, but the last field trip my wife went on. And I said, okay, did she decide she wanted to be a volunteer person to go on the field trip, or did she go on the field trip because she was afraid that no one would be there to ensure that the child is safe? And she wanted to go on the field trip, and that's okay. Any parent could participate in a field trip if that's offered to all parents. But a school cannot rely on a parent or require a parent to go on a field trip in order to meet the child's needs. So best practice, we know what field trips happen every year in town here, right? My son goes to the schools here. I know what's coming up this year. Have the team talk about field trips. Talk about after-school activities. If every year the school goes to, is it Bog Hollow? I think that's one of the field trips in the elementary school. We know Bog Hollow is going to happen. If you have a student who has a 504 plan, talk about that child's plan within the context of the upcoming field trips. If you're not meeting annually, you can't have that conversation. So that's a piece of why it's really, really important to make sure those conversations are taking place. The other piece where there's overlap between IDEA and Section 504 is discipline. So virtually the same standards apply. If a student is, if a district intends to exclude a student for more than 10 days prior to that exclusion exceeding 10 days, the team must convene. The team means a group of persons knowledgeable about the student and knowledgeable about the evaluation data. It does not mean the school disciplinarian, the parent, and the student. So it can't be, if the assistant principal is the disciplinarian, it cannot be the assistant principal, the student, and mom. Now, if the assistant principal is a regular member of the team, and that assistant principal is knowledgeable about the student, then of course that assistant principal should be included and invited. But it should be the folks who are convening to develop the plan and the folks who are knowledgeable about the student to conduct that manifestation determination. The other piece that is oftentimes overlooked are patterns of exclusions. And you mentioned that earlier. That is, if a student is excluded for a half day every single third period of every fourth day, and it happens to be when Spanish is taking place, schools should be tracking that. If a student is excluded for 3 days at a clip every 2 weeks, there should be someone watching. The first exclusion's 3 days, second exclusion's 6 days, third exclusion's 9 days. Before that fourth 3-day exclusion, if that's going to happen, someone should be watching and convene the team. So it's not only a, day after day after day, more than 10 days, it's a pattern of exclusions. And you have to be looking at the nature of the disciplinary infraction to make sure that there is, in fact, a pattern. Yes?
How would a parent know if their child's being excluded? Would a note come home, from the principal, or, you're mentioning a pattern of exclusion, but how would someone that's not in the school know about it?
So if the child is able to communicate to their family and is saying, well, I spent the day in the guidance counselor's office today, and they say it once, but then you're noticing, oh yeah, I spent all afternoon in the guidance counselor's office, then ask the question, reach out to the school. I keep hearing that my child is spending the afternoon in the guidance counselor's office. What's going on? Should we be reconvening? I always encourage a collaborative approach. Have a conversation, try to get a sense of what's going on. If you hit a roadblock, then you can reach out for additional resources. But it is difficult to rely on a student for the information, but unfortunately that's oftentimes what happens. In the cases that I've investigated historically, where there is a problem, I've seen a parent bring forward a concern that's this big, and then as soon as I get into the school district and investigate, I learn that the issue's not this big, it's about this big. And it's information that the parent just didn't have access to. So one example is asking for those records, so the speech records, and asking in a reasonable time frame. So asking for the school district to produce every third day logs is going to be really difficult, especially when you're dealing with a school that has 700 students, 1,500 students, however big the school is. So there's a reasonableness to the records request as well. A reasonable amount of time for you as the parent to know whether or not the services are being received. That's critically important. You don't want to wait every 6 months and then by then the students missed a ton of services, but reasonableness from the school's perspective as well. So it is asking those questions, regularly meeting with the teacher, finding out how things are going, talking about it during the team process. I have seen cases where I've looked into, on the speech front, one parent raises a complaint that speech services aren't being provided, and I end up investigating the school district and finding out that it's not just one student's impacted, there are 25 kids who are impacted, and then we reach out individually to those parents and make sure the compensatory services are provided to those families. So unfortunately, sometimes that happens. In other cases I've seen, where a school district loses a speech therapist and then they hire someone else, and so there is a gap, but as soon as the new person is hired, the school district is building in compensatory services. So I've really seen school districts do the right thing on that front as well and do the best they can to make up those services for the student. Okay. Other obligations, 'cause I'm running short on time here. Physical accessibility. So under Section 504, Title II, schools must be accessible to students, physically accessible. We talked a little bit about bullying before. Under Section 504, students with disabilities are protected from harassment on the basis of disability. So if you hear the word bullying and your kiddo is on a 504 plan or an IEP, the school should be asking the question, is it disability-based? Is it related to the student's disability? Because there's a heightened level of protection. It's not just bullying that reverts you to the Massachusetts state law. You are protected under federal law as well. If a school district is not acting in a manner to protect the interests of the students, so promptly and effectively responding to notice that a hostile environment exists, then they are not in compliance with Section 504. So really, really important. If harassment is taking place on the basis of a protected class, so protected class being race, color, national origin, gender, disability, then you're protected under federal law as well. So that's a real important takeaway. And then non-academic services, I talked about those earlier. This is your extracurricular activities, after-school activities. Students with disabilities must be afforded the same opportunity to participate. Other obligations, district must have a 504 coordinator, they must have grievance procedures, and they must have procedural safeguards, right to review records, and so on and so forth. Let's see. Most common violations that I've seen, failure to implement an IEP or 504 plan. Oftentimes that comes about because the right people aren't around the table at a team meeting. So the team meets and everyone decides on this incredibly robust 504 plan or incredibly robust IEP, yet no one has a conversation about whether there are enough service providers to actually implement the plan. So school starts, the kiddo goes to school, and there aren't the requisite number of staff to implement the hours that are put in across the board of all the IEPs or 504 plans developed, and ultimately an implementation issue takes place. Failure to provide procedural safeguards. So at critical junctures, identification, evaluation, and placement, and annually as a best practice under 504, IDEA, the obligations are pretty similar. A little bit more strict in IDEA, in the IDEA world. But school districts must notify parents of their system of procedural safeguards. It's oftentimes the stapled together procedural safeguards packet from the State Department of Education that has like stick figures on the cover. That's okay because in Massachusetts, you can go to PQA for both 504 matters and IDEA matters. Failure to identify a knowledgeable 504 coordinator. I've seen that in school districts many, many times where there's a person who happens to be Administrator X, and surprise, they're also the 504 coordinator, but no one told them that until their school is being investigated and they received no training and don't really know what 504 is. Physical accessibility concerns, so a student cannot access the school facilities, or there's a whale watch and no one's planned for the student who has a mobility impairment who can't access the whale watch. Yes?
Is training required?
In order for a 504 coordinator to be designated, they need to be knowledgeable. So you might have a school district that hires someone who is very knowledgeable about 504, and the fact that they don't receive training 1 year is in itself going to be a violation. So it's a tricky question. So, I mean, not to pat myself on the back, but if I were the district's 504 coordinator, I've been doing this work for 15 years, probably a little bit more. The amount of training that I would need in 504 would not be the same as a person who's never worked in the realm of 504. So it's enough training so that the person is knowledgeable about all compliance areas under Section 504. So, because the obligation under Section 504 is that the district designate one person or more to coordinate the district's efforts to comply with Section 504. So it's not just in the realm of implementation of a plan, we're talking about employment, we're talking about harassment, we're talking about grievance procedures, we're talking about least restrictive environment. It's the whole array of compliance under Section 504. So the person has to have sufficient training that would allow them to have the knowledge base to be considered knowledgeable about Section 504. You know, the law is always changing. We were talking earlier about Title IX and how that's an ever-moving target in my world. 504 has been a little bit less fluid, but the law is always evolving, so it's so important that people are constantly educating themselves to stay up to speed. So if you're not receiving ongoing training, ultimately that will reach a threshold where it presents a problem. Okay. All right, and I think we're now in the realm of questions.
And I think we'll, just so folks in the audience know, I think we'll stop filming at this point, so people, if you didn't want to ask a question on camera earlier, now is your time.
Cool.